Good morning. Today I'll be going into the last topic of our syllabus, which deals with the amendment of the Constitution. So, at our initial classes, when we had just started about what is a constitution, I was already telling you that the constitution is not a static organ, it is a living organ which has to grow and change with the changes in the society from time to time. Now, how are these changes to be made adopted in the constitution? So, there is a need for a particular procedure for the changes to be made to the constitution. So, such changes may affect the political or the social or economic conditions of the society. So, these changes have to be adopted with into the constitution with the changing needs of the time. So, our framers had introduced a specific provision for the amendment of the Constitution under Article 368. When we look at the formal procedure which has been formulated by the framers under the Indian Constitution, basically we see that there are three classes of amendments made which can be made to the various provisions of the Indian Constitution. The first one is a comparatively less significant, where less significant articles can be amended by a simple legislative process, which is similar to the procedure of passage of an ordinary legislation in the parliament. So, which we normally call as we pass it by a simple majority. So most of the some of the articles, not most of the articles, but some of the articles of the Constitution make provisions which are of tentative nature, and wherein Parliament has been given the power to make laws making different provisions different from what these articles provide for. For example, we have this citizenship. For citizenship, we depend upon the Citizenship Act which is being made by the Parliament. Is it not? So similarly, when a new state is being adopted into the country, when the nation acquires a new state, we have already read under Article 2. So consequential amendments have to be made under Schedules 1 and 4. So all these are dependent upon a law which is being made by the Parliament, and which does not require any kind of an amendment procedure rather. So a simple passage or a simple change can be effected by means of a simple majority. So such articles which deal with which are related to a law passed by the Parliament are not of that nature which requires an amendment to the Constitution, and do not fall within the purview of Article 368, and can be passed by a similar manner by which an ordinary legislation is being passed. So I've already mentioned two examples, like when a new state is being acquired under Article 2, when a law is being made for acquisition and termination of citizenship under Article 11. Then when the salaries of certain constitutional officers are going to be made, going to be changed, then even those, or when certain parliamentary privileges are to be defined. So all these are examples which do not require a basic amendment of the Constitution. They can be passed by an ordinary passage of a legislation, and so this is called as these changes can be effected by means of a simple majority, and they do not fall within the purview of Article 368. Now, what are going to be falling within the purview of Article 368 are those provisions which are material and vital, are made relatively stable, as these can be amended only by following the rule of special majority as laid down in Article 368, and those constitutional provisions relating to the federal character which may be characterized as the entrenched provisions which need for their amendment in addition to the passage of amending bill by the special majority in the two houses of the parliament, ratification by half of the state legislatures. Now these two procedures which requires the passage of a bill by means of a special majority, and the second one is which is passed the amendment of the provisions which require the passage of bill by means of a special majority, as well as by the ratification of more than half of the states. These two come within the purview of Article 368. Now, when we look into the entrance, the passage of a bill by special majority means, we have already discussed about what is special majority a number of times. We says the special majority means the acceptance of a particular bill by by the entire members of the house and by 2/3 of those present on the date of voting. So this is by means of a special majority. Now, when we come to the procedure where ratification of half of the state legislatures is required, now they are of certain provisions which are relating to the federal character of the constitution. Now we will look into what are those entrenched provisions. So for example, the manner of elections of the president under Article 54 and 55, the extent of the executive power of the union and the states under Article 73 and 162, the Supreme Courts and any provisions relating to the Supreme Courts and the High Courts, the scheme of distribution of legislative, taxing and administrative powers between the union and the states, and the representation of the states in the parliament, and any amendment brought under Article 368 itself comes within the ambit of the entrenched provisions which require the ratification of more than half of the states. Now, whenever the question of amendability of the Indian Constitution comes, since 1951, questions had been raised about the scope of the constitutional amending process contained in Article 368, and one of the basic questions which had been raised was whether the fundamental rights were amendable so as to dilute or take away the fundamental rights through a constitutional amendment. And since 1951, a number of amendments had been brought in to the fundamental rights, have been made to the fundamental rights, and the cumulative effect of these amendments had been to curtail to some extent the scope of some of these rights, and some of the rights were been limited, especially at that particular point of time. The right to property was always a controversial right, there was always a conflict between the state and the fundamental rights. Now, so the basic question was whether the fundamental rights could be amended within the purview of Article 368. If you remember, we had dealt with all these provisions when we were doing Article 13, when we were discussing about whether the constitutional amendment will be treated as a law defined under Article 13 Clause 2. So at that particular point, I was telling you about the inclusion of the new clause under Article 13, which said that the constitutional law or or an amendment made to the constitution cannot be considered on par with the ordinary law passed by the parliament. So we will be looking into those again, because now those changes which had been affected under Article 13 had also affected Article 368. So Article 13 and Article 368 were very controversial in nature at that particular point of time, and amendments were brought to both these articles. So the worst affected fundamental rights was the right to property, which was contained in Article 31 then, and which has been amended several times. Now, the basic trend of these amendments was to immunize to some extent the state interference with the property rights from challenges under Articles 14, 19 and 31, and also to seek to exclude the question of compensation for acquisition or requisitioning of property by the state from judicial review. So obviously, whenever the state had to perform its functions, obviously it required the land, and whenever it went to acquire land, obviously the citizens started claiming it to be their fundamental right to own the property. So there was a conflict between this social reform to be brought in and the fundamental right, and so they wanted Parliament always tried to amend or to curtail this particular fundamental right from clashing with the right of the state to acquire land, and also from prohibiting the people from asking for compensation for the acquiring of land. So many of these amendments which are made were always questioned in the court of law. So we will be discussing the consequence of these constitutional validity of these amendments which were made. So the first case was Shankari Prasad Singh versus Union of India in the year 1951, AAR 1951, Supreme Court 458, and it questioned the amendability of the constitution, curtailing the right to the property guaranteed under Article 31, and it questioned the first Amendment Act of 1951. So obviously the argument was against the validity of the First Amendment was that Article 13 prohibits the enactment of any law infringing or abrogating the fundamental rights, and the word law in Article 13 would include any law, even a law amending the constitution, and therefore the validity of such a law could be judged and scrutinized with reference to the fundamental right which it could not infringe. So if you look at what was Article 13, Article 13 said that any law made which violates the fundamental rights of the citizens was to be considered as void. Now that was there, the question was in relation to the word law. Now here the ambiguity was whether, now here a constitutional amendment was effectuated. It was not a new law made by the Parliament. So here the question was whether a constitutional amendment would also fall within the purview of Article 13, since it effectuated it is also passed by the Parliament in a similar way as it is passed it passes an ordinary legislation, and so it should be questioned as an ordinary law. A constitutional amendment is also on par with an ordinary law, and any law which violates the fundamental right is supposed to be considered as void. Now, the court held that the terms under Article 368 are perfectly general and empower the Parliament to amend the Constitution without any exception. The fundamental rights are not excluded or immunized from the process of constitutional amendment under Article 368. These rights could not be invaded by legislative organs by means of laws and rules made in exercise of legislative powers, but they could certainly be curtailed, abridged, or even nullified by alterations in the Constitution itself in exercise of the constituent power. So now here the court brought in a clear demarcation between an ordinary law which is made in exercise of a legislative power and a constitutional law which is made in exercise of its constituent power. So now it says, if any law is made by the Parliament, exclusively by the Parliament, a new fresh law is made by the Parliament which is invading the fundamental rights of the citizens, yes, it is considered to be void. But here you are not talking about any ordinary law which is being made. You are talking about an amendment which is going to be brought to an already existing provision in the Constitution. So here the court clearly said that you can't be equating a passage of an ordinary law to a constitutional amendment made under Article 368. So, while making this demarcation, the court clearly said that no, it cannot be questioned, and it validated the First Amendment Act, saying that no, First Amendment Act is valid, and the Parliament can make any limitations on the fundamental rights. It can also amend the fundamental rights, and it cannot be questioned as violating the fundamental rights under Article 13. So it clearly said that the constitutional amendment will not come within the purview or definition of law which has been stated under Article 13 clause 2. Now this went on for the next 13 years. And following the Shankari Prasad's case, another question was raised in 1964 in Sajjan Singh versus State of Rajasthan, AAR 1965, Supreme Court 845, when the validity of the Constitution 17th Amendment Act of 1964 was called in question. This amendment again adversely affected the right to property, and by this amendment a number of statutes affecting property rights were placed in the 9th schedule and were thus immunized from the court review. So if you remember, we were talking about the 9th schedule, wherein any any enactments made by the Parliament to protect especially the agrarian laws or the land reform acts, they were to be protected from judicial review. They included a new schedule called the 9th schedule, and those laws which were being placed in the 9th schedule were immune from judicial review. So the judiciary could not interfere in those laws. They could not talk about the validity, constitutional validity of those laws which were placed in the 9th schedule. So we'll be coming later on how this was misused, and all the laws which were not even concerned with the agrarian laws or the land reform laws were placed in the 9th schedule. I'll be coming to that a little later. But at this point of time, since all these laws which were made to protect the agrarian laws or land reform laws from judicial scrutiny, obviously the courts were tied up. They could not question the validity of the constitutional validity of these amendments. So now the validity of these laws being placed in the 9th schedule was questioned in this particular case, and by a majority of 3:2, the court upheld the principle which was laid down in Shankari Prasad's case, and the court came to a conclusion that Articles 13 and 368 and it brought out the relationship between Articles 13 and 368, and it did not hesitate in holding that the power of amending the Constitution conferred on the Parliament under Article 368 could be exercised over each and every provision of the Constitution, and the majority refused to accept the argument that the fundamental rights were eternal, inviolate, and beyond the reach of Article 368. So they said, now when you are talking about the power which is being conferred on the Parliament to amend under Article 368, it can exercise, the power is conferred on the Parliament on each and every provision of the Constitution. Why you have to protect only fundamental rights? Why should you say that fundamental rights are placed on a separate pedestal? They said no, fundamental rights are not eternal, so they are also prone to be amended. So they also brought a distinction between Article 13 and Article 368, and they said that any amendment made to the Constitution cannot be equated to a law passed by the Parliament, and they are on a higher pedestal. And so they said fundamental rights are also can be amended, and a constitutional amendment cannot be questioned that it violated the fundamental rights. However, Justice Hidayatullah and Mudholkar, these were the two judges who went against the majority judgment. And Justice Hidayatullah, he went on to say that to make me accept the view that fundamental rights were not really fundamental but were intended to be within the powers of amendment in common with other parts of the Constitution and without concurrence of the states, because the Constitution gives so many assurances in Part 3 that it would be difficult to think that they were playthings of a special majority. So he said, when you are saying it itself as fundamental rights, it itself shows that they are very fundamental in nature, and this could be amended, and to say that this could be amended even without the concurrence of the states, and that it could be amended like a small plaything, like change using a special majority, is something which is very grave, and which is something which is wrong. It's very difficult to digest. So he said it is not. The word fundamental itself means that it is something exclusive, so you are not supposed to be amending that, and anything which is amending the fundamental rights should be struck down, even though if it is a constitutional amendment. And Justice Mudalkar, he said that every constitution has certain basic features which should not be changed. Now he gave a minority view that if such a thing is going to be allowed, if such an exclusive power is going to be given to the parliament, so if it will go on amending whatever provision it wants, so that the basic or the essential features of the constitution will itself be changed. So tomorrow altogether new constitution will be brought up. Now this view of Justice Mudalkar was later highlighted in Kesavananda Bharati's case, and the basic structure theory came into being. So we'll be discussing about it. But these two are, in this particular case, were the minority view. So the majority view was different from the minority view. No, but encouraged by the above remarks made by Justice Hidayatullah and Mudalkar in Shankari Prasad's case, the question whether any of the fundamental rights could be abridged or taken away by the Parliament in exercise of its power under Article 368 was again referred to in Golaknath's case in 1967. It is LC Golaknath versus State of Punjab, AAR 1967, Supreme Court 1643. So again the same question which was raised in Shankari Prasad's, in Sajjan Singh's case, was questioned even in Golaknath's case. The question was in relation to the constitutional validity of the Constitution's 17th Amendment Act. And out of 11 judges, the 11 judges gave their decision, and it was divided by a majority of 6:5, and the majority overruled the Shankari Prasad's case and Sajjan Singh's case, and held that the fundamental rights were not amendable through the constitutional amending procedure set out in Article 368, while the minority upheld the line of reasoning adopted by the court in the Shankari Prasad's case and Sajjan Singh's case. So in this particular case, the majority overruled Shankari Prasad's case and Sajjan Singh's case, and stated that the fundamental rights were non-amendable through the constitutional amendment procedure set out in Article 368. So the majority was worried that at the numerous amendments which were being made to the fundamental rights which had taken place since 1950, and it apprehended that if the courts were to hold that the Parliament had the power to take away or abridge the fundamental rights, a time might come when these rights were completely eroded and India would gradually become a totalitarian country. So what is the need? Once you are giving them the fundamental rights, if you are also having the power to amend the fundamental rights whenever you want, then it is not a democratic country, it becomes a totalitarian country. So here the majority thus sought to make the fundamental rights inviolable by the constitutional amendment by ruling that the Parliament could not under Article 368 amend any fundamental right. So they said that if once the Constitution has made a particular right as fundamental right, the Parliament cannot amend that particular fundamental right. That was the majority, and the argument which was given by the Chief Justice was that he said that Article 368 laid down the procedure for constitutional amendment and did not by itself confer a substantive power to amend. The Chief Justice referred to the marginal notes under Article 368. So he took the notice of the court to the marginal notes, which are, or the marginal head notes, which are given to Article 368, which said that it is only talking about the procedure for amendment. The power for amending the constitution was not conferred under Article 368. So referring to that particular marginal note, the Chief Justice said that the procedure which is to be followed must be followed. But what is the power? The Parliament is not conferred with the power to amend each and every article it likes. The power to amend the Constitution was found in the residuary legislative power of the Parliament contained in Article 248. If you remember, we were talking about the residuary powers of the Parliament when neither of the subjects are mentioned in the three lists. Then you have a particular provision under the union list which talks about the residuary powers, and such power is conferred to the Parliament to make laws on that particular subject. So he said that the power to amend the Constitution is not found under Article 368. The power to amend the Constitution is found under Article 248, which is the residuary power of the Parliament. Alright, and because such a power was not expressly conferred by any article or legislative entry in the Constitution, the power comes within the ambit of Article 248. Accordingly, an amendment to the Constitution would be a law for the purpose of Article 13. So, how beautifully he has brought in a argument wherein he brought to the notice of the procedure which is only conferred under Article 368. The procedure to be followed by the Parliament to amend the Constitution was only conferred under Article 368. Article 368 does not confer the power. Now then, from where does the Parliament get the power? The Parliament does not have any power to make any amendment it wants. So where does the Parliament gets its power? The Parliament is getting its power to amend only from Article 248, and Article 248 is in relation to a law which is being made by the Parliament. Right, it comes within the ambit of the union list. So the subjects in the union list are those subjects which the Parliament has the power to make law. And so how beautifully he has related the fundamental the amendment which they are bringing, the constitutional amendment, is not under 368 but it comes under Article 248. And so because it comes under Article 248, it comes within the ambit of Article 13 clause 2, which is defining a law, and whenever it comes within the ambit of law, it can be questioned when it is violating the fundamental rights. See how beautifully an argument was made by the Chief Justice in that particular case. Now, so overruling the position adopted by the court in Shankari Prasad's and Sajjan Singh's case, it was now ruled that the term law in a comprehensive sense would include a constitutional law. Alright, and it would come within the definition of law which has been mentioned under Article 13 clause 2. So here they have clearly said that an ordinary law and a constitutional amendment are not different. Even a constitutional amendment is also a law which comes within the ambit of 13 clause 2, and if it is going to violate a fundamental right, it should be struck down as invalid. So under Article 368, a constitutional amendment is to be enacted by following a procedure which is very similar to the procedure for making laws. The fact that a larger majority, and in case of amendment of some articles even ratification by the state legislatures, are provided for, would not make a constitutional amendment any less than a law. Therefore, the amendment made under Article 368 is law and is subject to Article 13. The Constitution Amendment Act in question was held void in as much as it abridged the fundamental rights. Thus, the majority ruled that the fundamental rights would fall outside the amendatory process if the amendment sought to abridge or take away any of these rights. So just because the word power was not included under Article 368, the power of amending the constitution, any provision of the constitution, was interpreted to be brought under Article 248, which is the residuary power, and thus was made on par with an ordinary law passed by the parliament. So thus making the state not to make any kind of an amendments which were going to abridge the fundamental rights. Now at this stage, obviously, because after Shankari Prasad's case and Sajjan Singh's case, which had given effect to these amendments, the state had made many laws which were violative of the right to property, and had effectuated and had implemented these laws. Now, if after this ruling, if the court was supposed to give an retrospective effect, then obviously the laws which have been effectuated or implemented over a period of between 1950 to 1967, almost 17 years if I'm right, then all these become chaotic. So because so many things had changed over a period of time because of the previous judgments, so now the court devised a new doctrine called the doctrine of prospective overruling, stating that this principle would come into effect prospectively and not retrospectively. So the laws which have been already made, and the effect of those laws which have already been implemented upon, will have no effect of this judgment, and this from the time of this judgment, in the future this judgment would hold good. So it will be having a prospective effect and not a retrospective effect, in the sense that after this judgment was given, the parliament was not allowed to make an amendment which was violating the fundamental rights. If it was violating the amendments of fundamental rights, it would be brought within the purview of Article 13 clause 2. So that was made very clear in this particular case. So just going into the basic principles which were laid down in the Golaknath's case. The first principle was that the substantive power to amend is not found in Article 368. This article only contains the procedure to amend the constitution. The second one was, a law made under Article 368 would be subject to Article 13 clause 2 like any other law. Third, the word amend envisaged only a minor modifications in the existing provisions, but not any major alterations therein. And fourth, to amend the fundamental rights, a constituent assembly ought to be convened by the parliament. So the majority opinion in Golaknath emanated from the premise that fundamental rights are fundamental and need to be protected. Now this case, the judgment given in this case was, it raised an acute controversy in the country. So there were two schools of thought. One school of thought applauded the majority decision as a vindication of fundamental rights, while as the other school criticized it for creating hindrances in the socio-economic legislations required to meet the needs of the developing society. So there was a mixed reaction of this particular judgment which was given in Golaknath's case. So what happened after Golaknath's case I will be taking up in the next session. So it is going to be a very interesting session. So the amendment, the topic of amendment of the constitution itself is a very interesting story, in fact. So it would be very interesting with how many twists and turns took place to understand this concept of the amendment of the constitution. So hope you understood the session. Please come back with doubts if any, and have a good day. Thank you. Good morning. In the previous session, we were looking into the concept of the amendment procedure of the Indian Constitution under Article 368, And while looking into the provisions, we also dealt in with the basic question as to whether a fundamental right was amendable, and if such a constitutional amendment violated the fundamental right, could it be questioned in any court of law? That is, could it be reviewed judicially? So we looked into three major important cases of Shankari Prasad Singh versus Union of India, Sajjan Singh versus State of Rajasthan, and Golaknath versus State of Punjab. In the first two cases, we found where the Constitutional First Amendment Act and the Constitutional 17th Amendment Act was questioned. We found that the court held that a constitutional amendment cannot be treated on par with the a law described under Article 13 Clause 2, and it is not prone to any kind of judicial review. Whereas the whole scenario was changed in Golaknath's case, where they said no, because the power of amending Article 368 only talks about the procedure of amendment. It does not confer the power, and the power to amend the constitution is a residuary power which is conferred to the parliament under the union list. So here, by virtue of it being in the union list, it is to be treated as a law on par with any other ordinary law, as has been defined under Article 13 Clause 2. So there was a chaotic situation as to whether a constitutional amendment should be treated on par with an ordinary law, because both of them were to be passed by the parliament. And if it is to be treated as law, could a constitutional be amendment struck down as violating any of the fundamental rights? Now, the later consequence of the Golaknath's case was an amendment brought out to Article 368 by the 24th Amendment Act. So it so happened that in 1971, after the general elections, the Congress party returned with a huge majority, and obviously once it came back to the majority, took over the power, it wanted to regain its power, which it lost because of the what do you say, amendments being diluted, the amendments power being diluted in Golaknath's case. So to retain back its power, it passed the 24th Amendment Act, which made certain modifications to Articles 13 and 368 to overcome the Golaknath's ruling, and to ascertain its power of the Parliament, which was denied in Golaknath's case. No, so the whole the 24th Amendment was basically brought to dilute the Golaknath judgment. So the majority judgment in Golaknath's case took a view that the word law in Article 13 included a constitutional amendment, and therefore fundamental rights could not be curtailed or diluted. So the 24th Amendment was brought in to dilute this position, which was held by the Supreme Court in Golaknath's case. So let us look into the changes which the 24th Amendment brought. The first one was that it clarified that Article 13 would not stand in the way of any constitutional amendment made under Article 368. So this was sought to achieve by adding a new clause under Article 13, which clearly declared that Article 13 shall not apply to any constitutional amendment made under Article 368. If you remember, I was telling you about Clause 4 of the Article 13, which clearly stated that a constitutional amendment will not be brought within the purview of Article 13. Now, the second proposition which was brought by the 24th Amendment was that a new clause was also added to Article 368, which declared that Article 13 shall not apply to any constitutional amendment made under Article 368. So a similar clause was added under Article 13 and also under Article 368, so that tomorrow nobody would question saying that this was only a clause which was inserted under Article 13 and not under Article 368. So as a matter of abundant caution, the same clause was also inserted under Article 368, which clearly stated that a constitutional amendment was not similar to any law which was defined under Article 13. And the next contention which was raised in Golaknath's case, especially in the marginal note where the Chief Justice raised the point that the marginal note of Article 368 says that it talks only about the procedure by which the Parliament can amend the Constitution. It does not confer a power on the Parliament to amend the Constitution. Now, to make a change and to get the power, so the marginal note of Article 368 was changed. It was changed from procedure for amendment of the Constitution to power of the Parliament to amend the Constitution and procedure therefore. So now a power was also added to the Parliament so that nobody could question the power of the Parliament to amend the Constitution. Now the next change was that a clause was added to Article 368 which said that notwithstanding anything in this Constitution, Parliament may, in exercise of its constituent power, amend by way of addition, variation, or repeal any provision of this Constitution in accordance with the procedure laid down in this law. So, after saying that it has also been conferred with the power, now it made it very clear that it has the power to amend, vary, or repeal any provision of the Constitution in accordance to Article 368. Now the amendment now excluded any kind of inference being drawn by expressly including the fundamental rights within the scope of amending process. So by saying that it includes the power to amend, vary, or repeal any provision of the Constitution, it impliedly brings into the concept of amending the fundamental rights also, so thereby clarifying that the Parliament can amend the fundamental rights. Now, a view was expressed in Golaknath's case that there was no difference between an ordinary law made under the legislative process and a constitutional amendment made under the constituent power. Now, so it had been pointed out that in Golaknath's case, it was pointed out that the presidential power to assent or refuse to assent were both similar in both cases. In the case of an ordinary law, also he had the power to either assent or to reject, or which we call as a limited veto power exercised by him. So similar was the case with the amendment also. So a amendment made to the Constitution could either be accepted or rejected by the President. So in Golaknath's case, they brought out a point saying that since the assent of the President in both the cases are the same, then it should mean that a constitutional amendment is similar to an ordinary law passed by the Parliament. Now, to overcome this, the 24th Amendment clearly brought into a provision which stated that a constituent amendment bill, once it is passed by both houses of the Parliament by requisite majority in accordance with the procedure laid down in Article 368, the President would have no option but to give his assent to it. So now they have made a change stating that the President has no veto power over any amendment, constitutional amendment, which has been passed by the Parliament with the required majority. So he has no power to veto in relation to it. So now this particular 24th Amendment has clearly brought into a distinction between an ordinary law and a constitutional law. Now, along with this 24th Amendment, there was another amendment called the 25th Amendment, which was passed by the Parliament. Again, we'll just look into the what do you say, the framework of 25th Amendment, because these two are later on questioned in Keshavananda Bharati's case, which is very important. So here, and this was mainly in relation to the right of property. It was related to the fundamental right of property. So what were the features of the 25th Amendment Act were? The first one was that the word amount was substituted for the word compensation in Article 31 Clause 2. This was done to remove any contention that the government was bound to give adequate compensation for any property acquired by it. So now, what is the amount? So the word amount was substituted by the word compensation. When you say that this much of amount is going to be paid, so the word amount is more specific in nature. But when we talk about the word compensation, it is totally, it has a wide connotation. So you cannot be fixing compensation, and the fixation of the compensation is done by the court keeping in mind various parameters. So here, so they wanted to dilute it. They did not want the amount to be fixed. So normally when a land is being acquired, what do? We do the government usually pays the owner based on the market value, but it is not always done so. So in certain cases, the government may be paying. So now, to have a flexibility in paying the amount to the owner, they have replaced the word amount with the word compensation. The word amount was substituted for the word compensation, and this was done to remove any contention that the government was bound to give adequate compensation. Now, why? I'm sorry, I have in fact told you to in the other way. Now, when you're talking about amount being fixed, now obviously the amount cannot be fixed. So what I was trying to tell you was, previously it was compensation. So compensation was to be decided by the government depending upon the various parameters, and whether the compensation was adequate or not could be looked into the court by the court. But whether the compensation needed to be paid or not was not binding. So here they said, let us substitute the word amount was substituted for the word compensation. So they changed the word compensation and made it amount, so that the government is bound to pay some amount. Now then, when Article 19(1)(f) was delinked with Article 31 Clause 2. So because Article 19(1)(f), which was a right to property then, which existed then, was always linked with 31 Clause 2. So now they separated. They said no, 19(1)(f) has nothing to do with Article 31 Clause 2. And the third provision was in relation to a new article being added to the Constitution, Article 31C. We have already discussed about Article 31C in detail when we were doing the directive principles of state policy. So these were the three changes which were brought in by the 25th Amendment Act. And obviously, I said whenever there is a new amendment, obviously it will be the constitutional validity of it is bound to be questioned in the court of law. And similarly, these two amendments, were questioned in the case of Keshavananda Bharati versus state of Kerala. And this was questioned by Swami Keshavananda Bharati, a Mutt chief of Kerala, and the matter was heard by a bench consisting of 13 judges. Why? Because the Golaknath's case was held by a bench of 11 judges, so it needed to be higher than, because it was questioning the validity. The 24th Amendment Act was brought to dilute the Golaknath's case. So obviously the number of judges in the bench had to be higher than the Golaknath's case. So let us look into what the judgment delivered in Keshavananda Bharati's case. The judgment was delivered on 24th April 1973. Now, the following are the important points which were held in that particular case. The first one was, the court held that the power to amend the constitution is to be found in Article 368 itself. It also emphasized that the provisions relating to the amendment of the constitution are some of the most important features of any modern constitution. So he said the court first clarified that any kind of amendment which is being made should be made as per the procedure which has been expressed under Article 368. Further, the court recognized that there is a distinction between an ordinary law and a constitutional law. So I was telling you that, so it has, by validating the 24th Amendment Act, wherein it said it brought into a change of under Article 13 and Article 368. So it was clearly asserted that an ordinary law cannot be compared with a constitutional amendment made under Article 368, and both were distinct. And so to this extent, the view which was given in Golaknath's case was overruled. Next, it said that in relation to the unlimited amending power to the parliament. Now, when you look at the 24th Amendment, it said that it can amend, vary, add, repeal any provision it wants. Now, so to this extent, the court did not accept, and it did not accept the unlimited amending power of the parliament under Article 368. And it said that the amending power was subjected to one basic and significant qualification, that is, it should not destroy the basic or fundamental features of the constitution. So a constitutional amendment which offends the basic structure of the constitution is ultra vires. So while upholding that the ordinary law is separate from a constitutional amendment, it cannot be questioned and all that, it cannot be brought within the purview of Article 13, it now brought in a limitation on the amendment power of the parliament itself. It said that the amendment power of the parliament is not unlimited, it is limited to the extent of the basic features of the constitution. So, and while talking about the basic structure doctrine, it also gave certain features. So the judges gave certain features, like for example the supremacy of the constitution, republican and democratic form of the government, the secular character of the constitution, separation of powers between legislative, executive and the judiciary, the federal character of the constitution. So these are some of the features which the court felt are the basic features of the constitution, and any amendment which is going to violate these basic features are considered to be ultra vires and are liable to be struck down. So this meant that while Parliament can amend any constitutional provision by virtue of Article 368, such a power was not considered to be absolute and unlimited, and that will still go into the question as to whether or not an amendment destroys a basic fundamental feature of the constitution. If the amendment does so, it is constitutionally invalid. So this clarification was brought in Keshavananda Bharati's case. The next one was, now what, when the court held that certain basic features, certain fundamental features. Now what are these fundamental features? Does the constitution itself talk about it? No, it said, the court said that what is a fundamental feature itself is a debatable point, and the list given in this particular case was not considered to be exhaustive, and it left it to the courts to decide when, as and when the question arises whether a particular amendment of the constitution affects the basic or fundamental feature of the constitution or not. So the question of basic feature has to be considered in a case to case basis, and it is not a concrete or a fixed list of features. So now when you compare the Keshavananda Bharati's case with Golaknath's case, you find basically the ruling of Keshavananda Bharati's case to be an important improvement of the Golaknath's case in basically in two significant aspects. First one was where they said that the fundamental rights, the amendment of the fundamental rights can be done, and it is going to be treated on par with any law being made by the parliament. So the first distinction of an ordinary law with the constitutional amendment. So the court clarified that there is a distinction between the ordinary law and the constitutional law, and Now, the second part, where the second significant change, which stated that the fundamental rights in Golaknath's case, which said that the fundamental rights are non-amendable, and so in the Kesavananda Bharati's case, the court felt that this particular preposition was quite rigid, and so it wanted to give some kind of a flexibility. So it said that not all fundamental rights are now to be regarded as non-amendable, but only such of them as may be characterized as constituting the basic features of the constitution. So now in Kesavananda Bharati's case, to a certain extent they said yes. The Golaknath's case, they said fundamental rights are non-amendable. You cannot be amending the fundamental rights, because if you are going to amend, it is going to come within the purview of Article 13. Now he says that it is not that the fundamental rights cannot be amendable, but only those fundamental rights which have been given the status of a basic structure cannot be amended, but the rest of the fundamental rights can be amended. So basically in these two respects, the Kesavananda Bharati's case is considered to be more a significant case than that of the Golaknath's case. So now, according to the Supreme Court in Kesavananda Bharati's case, even a fundamental right can be amended or altered, provided that the basic structure of the Constitution is not damaged in any way. Now, it is for the court to decide on case-to-case basis as to which fundamental right is to be treated as a basic feature, and the right to property has not been treated as such, and so the right to property has been abrogated. So because of this, they have abrogated the right to property and they have made it as a constitutional right. Now, there's one of the valid questions of the constitutional validity of the 24th Amendment. The entire 24th Amendment was held valid by the Supreme Court in Kesavananda Bharati's case. Now, looking into the constitutional validity of the 25th Amendment Act, the court said that although amount was not the same as compensation, and while the courts could not go into the question of the adequacy of the amount payable for property acquired or requisition, and yet the amount could not be illusory or arbitrary, so the amount need not be of the market value of the property acquired, but it could still have some reasonable relationship with the value of the property, and thus a limited judicial review of the amount payable for the property acquired was still possible. So while giving a clarification of the word amount used in place of compensation, so they said although there is the concept of amount is considered to be vague because you are not fixing it. It can be illusory and it can be arbitrary also. So the court held that although it need not match with the market value, but there has to be a reasonable relationship with the amount which is being given in the form of compensation to the owner. So that to that extent there is a limited judicial review of by the judiciary. And the non-application of 19(1)(f) to the law enacted under Article 31 Clause 2 was held to be constitutionally valid. And in relation to Article 31 Clause C, I was telling you that those laws which were made to give effect to 39B and C, and if they were violating Article 14, 19 and 31, they would be validated. That was the first provision of under Article 31C to give effect to the directive principles under 39B and C. And the second provision of that particular clause said that any law which declared that this was made to give effect to Article 39 Clause B and C should be validated and should not be reviewed. Now the court struck down the second part of Article 31 Clause C, because if such a declaration was allowed to be made, then every law would have such a declaration. So it would be more fraudulent in nature. So the court did not accept the second part of the clause of Article 31C. It struck down that and it upheld the first clause, wherein it said that any law which was needed to validate 39B and C, although it violated Articles 14, 19 and 31, could be held to be valid. This was to the extent of the Kesavananda Bharati's case. Now, what was the aftermath of the Kesavananda Bharati's case? So, the next case in which the Supreme Court had an occasion to apply Kesavananda Bharati's ruling in regard to the non-amendability of the basic structures of the Constitution was Indira Gandhi versus Raj Narayan. This is also a very important case in the year 1975. Here the question involved the validity of Clause 4 of the Constitutional 34th Amendment Act of 1975. Now, the Clause 4 of the amendment was challenged as destroying the basic feature of the Constitution insofar as it constituted a gross interference with the judicial process. Now, the Supreme Court upheld the contention and declared that Clause 4 was unconstitutional. The first part of Clause 4 was regarded to violate the essential features of the Constitution, and accordingly it destroyed an essential feature, democratic feature of the Constitution. Now, the mechanism for determining the real representativeness of the people in an election as contemplated by the Constitution was to have a free and fair elections. Now, if you remember the case of Indira Gandhi versus Raj Narayan, it was in this particular case that it was the court gave a ruling that there had been what do you say, a corrupt practice committed by the Indira Gandhi government to win the elections, and so her post of prime ministership was at stake. So then she brought out an amendment to the Constitution and added Article 329B, which said that any elections conducted in the country, the courts shall not have the power to question the validity of the elections. Now, obviously, now this amendment was violating the democratic feature of the Indian Constitution. So, after the Kesavananda Bharati's case, the court held that Article 329B, which restricted the judicial review of the questioning of the elections or the validity of the elections conducted in the country, was violating the democratic feature of the Constitution, and free and fair elections were considered to be a basic structure of the Indian Constitution. And similarly, in another case, another significant point which was made in this particular case by Justice Chandrachud was that the amending power and the amending power and the ordinary lawmaking power operate in different fields and are therefore subject to different limitations. A constitutional amendment is a law of a higher status, and so it cannot damage the basic feature of the Constitution. The amending power under Article 368 is subject to this overall restriction, but not the ordinary legislative power. An ordinary law has to be tested on the touchstone of the competence of the enacting legislature and whether it infringes any other specific constitutional interdiction. So there now, even in this particular case, they have differentiated between the ordinary law and a constitutional amendment. So this is about this was the case where a particular amendment, a constitutional amendment, was struck down as violating the basic feature. Now, the central government obviously now it did not relish the Supreme Court's pronouncement in Indira Gandhi's case. Obviously, it was a blow on their face. So, it declared that Clause 4 of the 39th Amendment was invalid and it struck down Article 329 Clause B. Now, the government was very much desired to ensure that in future the court should not have the power to pronounce any kind of a constitutional amendment invalid. So, they were bent upon making an amendment which is going to restrict the courts to interfere in its amending process. So, Article 368 was again amended by the 42nd Amendment Act. So now again they amended. Now what did the 42nd Amendment Act do? Now the 42nd Amendment Act has lot of significance because it has amended so many different provisions beginning from the preamble itself. So this is also one of the significant changes which it made. Now how far was it considered to be valid, or was it considered to be invalid? We'll see. Now, the 42nd Amendment sought to ensure that the constitutional amendment may not be challenged before any court on any ground whatsoever. And to achieve this objective, two new clauses were added to Article 368. Now, these clauses were very broadly worded and were designed to make it clear that the judiciary should be to the judiciary that there should be no limitation whatsoever on the Parliament's constituent power under Article 368. Now it added two clauses, clause 4 and clause 5, and clause 4 mentioned above said that even went to the extent of reviving the constitutional amendments held invalid by the Supreme Court earlier, and the second limb of Article 31C in Keshavananda Bharati's case, and a few clauses of 39th Amendment in Indira Gandhi's case. Clause 4 clearly said that under 42nd Amendment, clause 4 clearly stated that the court has no power to intervene with the amendments made by the Parliament, and it went on to such an extent saying, giving it a retrospective effect. So it wanted to dilute whatever judgments were made by the Supreme Court prior to this particular amendment. So it said that it is going to validate all the 39th Amendment Act. It is going to validate the second limb of Article 31C, which said that any declaration made to give effect to Article 39B and C should not be reviewed by the judiciary. So as per this clause 4 of the 42nd Amendment Act, the judiciary is not going to be interfering in the amending procedures, amending powers of the Parliament. It is not going to be dealing with the validity of the amendments, nor and it also gave a retrospective effect, diluting the previous judgments itself. So this was a grave effect clause which was given, because you cannot be superseding the judicial decisions. You can only amend it. The Parliament only has the power to amend it, but it cannot contravene a judicial decision, or you cannot go against a judicial decision, or you cannot be diluting a judicial decision. So this was given under clause 4 of the 42nd Amendment. Now, and another change was brought in relation to Article 31C. It said, when we were talking about Article 31C, the first part was to give effect to only 39B and C of the Directive Principles of State Policy. Now, the question that was the 42nd Amendment Act brought a change stating that why should it be only 39B and C? Why not it be for all the directive principles? So it said, let there be a law which is going to be giving effect to any directive principles shall not be brought into question in front of any court of law if it is going to violate 14, 19 and 31. Now, if such a thing is allowed to be made, then the concept of judicial review itself does not exist, because the Parliament makes laws based on the directives given in the directive principles, or based on the recommendations given in the directive principles. So if if such is the case, then there can be no review of the judiciary at all. So it was in the case of Minerva Mills case versus Minerva Mills versus Union of India, where the scope and extent of the application of the basic structure came up for discussion before the Supreme Court, and the petitioners had challenged the constitutional validity of clauses 4 and 5 of Article 368, which was inserted by the 42nd Amendment Act. Now, the Supreme Court unanimously held that clauses 4 and 5 of Article 368 of the 42nd Amendment was unconstitutional, transgressing and limiting the amending power, and damaging or destroying the basic structure of the Constitution. The court held that the Parliament cannot, under the exercise of that limited power, enlarge that very power into an absolute power. power. Indeed, a limited amending power is itself a basic feature of the Constitution and cannot be destroyed as is done by Clause 5. So also is Clause 4 unconstitutional because it excludes judicial review of the constitutional amendments. So when you are talking about amending the power of the amendments, the Constitution itself gives a limited amending power under Article 368, and which is itself a basic feature. Also, you cannot be enlarging your power to such an extent that it is going to violate the basic structure itself. Thereby, it said that Clause 5 itself is unconstitutional, and Clause 4 is unconstitutional. Why? Because judicial review is a basic structure, and so it cannot be violating the basic structure. So the 42nd Amendment Act, to the extent of inserting clauses 4 and 5 to the Article 368, was considered to be void. Now, moving further to certain cases which dealt with the principle laid down in Keshavananda Bharati's case. In Vaman Rao versus Union of India, which was a case in 1981, the Supreme Court held that the amendments to the Constitution which were made before 24th April 1973 and by which the 9th schedule was amended from time to time were valid and constitutional. Amendments to the Constitution made on or after that date by which the 9th schedule was amended were left open to challenge on the ground that all or any of them were beyond the constituent power of the Parliament, since they damaged the basic structure of the Constitution. Now, since the basic structure theory was brought in or devised only in Keshavananda Bharati's case, so they kept the date of the judgment of Keshavananda Bharati's case as a cutoff date. So I said it was only a prospective effect, it was not a retrospective effect. So all amendments which were made prior to the 24th April 1973 and all laws which were inserted in the 9th schedule, we already discussed about the 9th schedule, so they were immune from judicial review. But after 24th April 1973, all those laws or all those all those which were made and kept in 9th schedule, all those amendments which were made and those which were placed in the 9th schedule were prone to judicial review if they were thought to be violating a basic structure of the Constitution. Similarly, in L. Chandrakumar versus Union of India, the Supreme Court held that Article 323A and 323B excluded the jurisdiction of the Supreme Court under Article 32, and the High Courts under Article 226 were unconstitutional. And in S.R. Bommai versus Union of India, it stated that it reiterated that judicial review was a basic feature of the Constitution, and it also stated that secularism was considered to be a basic feature of the Constitution. In M. Nagaraj versus Union of India, in the year 2006, the court laid down that in the matter of application of the principle of basic structure, twin tests have to be satisfied. So they laid down two tests, whether as to how you're supposed to be using the principle of basic structure. They called it as Wick test and test of identity. And it was clarified that not an amendment of a particular article, but an amendment which adversely affects or destroys the wider principles of the Constitution, such as democracy, secularism, equality, etc., is impermissible. So when you're talking about amendment of the article, you're not going to be talking about the exact amendment of that particular article alone. You are going to be looking into the effect of that amendment to that particular article and its effect on the other articles also. That is why you call it as a width test and the test of identity. How width or how broad is its effect? If its effect is going to be on other articles also, then it is going to be wide. So they said the basic structure is not going to be limited to that particular article alone which is going to be amended. The effect of the amendment to other articles relating to that particular article is also to be taken into consideration. Similarly, in another case of I.R. Koilo versus State of Tamil Nadu in 2007, a 9-judge bench on this case is also called as the ninth schedule case. I was referring to Vaman Rao's case. So similar to Vaman Rao's case, here in IR Koilo versus State of Tamil Nadu, the Supreme Court upheld that the basic structure doctrine and the authority of the judiciary on the review of any of laws which destroy or damage the basic structure as indicated in Article 21 read with 1419 and the principles laying down thereunder, even if they are placed in the ninth schedule of the Constitution. So the similar principle of which was laid down in Vaman Rao's case was upheld, and a broader test was also laid down by the Supreme Court in this particular case. I am not going into the details of the particular case. If you are interested, you please go through this case. It's a very interesting case where they have dealt in to the tests which have to be required to decide upon the effect of the amendment on the basic structures. So these are some of the important cases. And to conclude, I would just like to bring out certain points in relation to the power and procedure of the constitutional amendment. So we'll look into certain important points. The first point is that there is no separate constituent body for the purpose of amendment of the Constitution, and the constituent power is being vested in the legislature itself. So there is no separate body which has been devised by the Constitution. The power is vested with the Parliament itself. Second one is, although the Parliament must preserve the basic framework of the Constitution, there is no other limitation placed upon the amending power. That is, there is no provision of the Constitution that cannot be amended. So, but for the basic structures, there is no other limitation on the amending power. But the irony is that today almost all the features of the Constitution, or most of the features of the Constitution, are basic features. So what is the limited power is a very big question mark. And the role of the states in the Constitution, amendment of the Constitution, is limited only to the extent of ratification by the state legislatures. The state legislatures participate in the amendment procedure. They cannot initiate any bill or any proposal for the amendment of the Constitution. So these are the basic points which I wanted to emphasize before I close down the last topic of your syllabus. So with this, I have completed the syllabus of your constitutional law part 2. So please let me know if you want me to discuss any other topics in relation to your syllabus. I will certainly do it. If you want, I would give an recording of my lecture in relation to that, because I've